Record, State's Attorney's present, defendant and defense counsel are present. The witness, Detective Carmouche, is here. Mr. Wilkerson had requested that we come back so he can take the witness on voir dire to clear up some things. Is that correct?
Yes, Your Honor.
Go ahead.
So, I guess let's start with Donald Barnes. Do you have knowledge as to whether or not Donald Barnes represented himself as his brother and vice versa?
I never knew that to be the case. I only learned by being told.
Okay. No personal knowledge, though. With regard to so let me just start rather with how many extractions were performed and on what devices?
So, Romeo Johnson, Mr. Berry was one, two, and then one was about to be processed on Mr. Job, but it was found that it was his son, so I quit that immediately. And some of the people at, I gotta go back and look, but I think some of the witnesses at the, or people I spoke with at the Heritage Inn, a couple of them out there.
Was there a hard drive, a Western Digital drive device that was extracted?
Yes.
Where did that come from?
So the Heritage Inn, they had a hard drive of everything, and I think we pulled tried to pull the entire drive, but we tried to, I think. I'm not sure if we were able to get it. I got Detective Freeman out there, I think. But
all right.
Those things are huge.
Yes, sir. Were the extractions of Justin Berry's devices turned over to the state?
I believe we were going to use it. I gotta go look at it and see. But I think so, because mainly we were going to use them to file against him for tampering evidence, but did not.
Do you know with certainty whether or not the Beaumont Police Department turned it over to the state's attorney?
What I recall, I remember doing the download as it being given to the state's attorney. I think I would. It was a pretty big file that I sent over. It was a big old passport, had everything on it, so.
Do you know any reason why that wouldn't have been turned over to us?
If it was not, it'd probably be just the volume. There's just excess volume of it.
I think arguably, at least from the report's indication, that device, or at least one of those devices belonging to Berry, allegedly had some incriminating messages on them, correct?
Yes. Some of the, it was the one with the picture you're speaking about?
I'm speaking about an allegation
Okay.
that he sent a text message saying that the defendant utilized his firearm.
Gotcha.
Do you recall that?
Yes.
Do you know or have any idea if there was anything exculpatory on that drive, like location data or anything that might have disproved?
Do not know. I don't think that drive, I don't think it had anything like that. I think the location services were off on that one.
Would you agree, especially given at least the allegation about incriminating evidence, that it would have needed or should have been turned over to the defendant.
So, would I agree, oh, I'm sorry.
Would you agree that that would need to be provided to us, generally speaking?
Yes.
Do you know who located the knife at the residence of Ronald and Donald Barnes?
Yes,
Who was that?
that was Detective
Detective
Gillen.
Gillen? Gill. And was there blood on that knife?
Yes.
Was the blood on that knife ever compared to the DNA of the defendant in this case, or Brandon Dodd?
No, how, well,
Please, you can qualify your answer, especially now.
no, so, in the previous pictures where you sit there and see the pictures of the scene, you can see the knife is actually sitting on the bedside table that's next to the door. It was just moved by somebody, I don't know if it was Detective Gillen or the crime lab, and left it there. So it was there in place, and it had blood, where blood spatter had been placed all over next to his body, the decedent's body. So it was there, it was, the detectives was picking it up and then putting it on the bed. And then the family showed up and just saw it, was like, oh, maybe this was something.
Was the, I'm a little confused, so you said that it's possible the detective or someone else moved it to the bed.
I want to say it was a detective, more like.
Would that have been before or after CID took photos of the scene?
After. So he was staying with the crime lab, Jefferson County Crime Lab. They took over the entire evidence, everything like that. They went through it, they looked at the knife and decided with the blood spatter and everything like that, it was there. And in the pictures you can see it, you can actually see it. And I guess at one point he decided to pick it up and then just put it on the bed.
Well, that's, I guess it being seen is the question. Would it surprise you that Ms. Hargrover testified that she did not take the photographs of that knife?
Well, yes, because the knife, when it was discovered, was on the bed, like the bed itself, like all the sheets were removed, and then that was on the bed, like appeared, but it did appear, it was just right after everything had finished up, somebody moved it, a detective moved it, put it there, and then just left, and then the family showed up, saw it, called me, asked me about it. I was curious, I was like, what's going on? I ended up going through all the pictures, and I ended up finding on the picture where you can see it on the actual dresser, and that dresser, or that end table is full of blood, so it makes sense that it was there.
So I guess, tell me what the purpose of, why we're doing this without the jury.
Well, so this, I'm not certain that it really needs to be done without the jury.
Yeah, we don't need to do things twice unless we have to. So what do we need?
Getting on to the cell phone extraction of the Samsung device, you reviewed the reports from that, correct?
One for Mr. Johnson?
Yes.
Yes.
All right. And location data on that specific device, isn't it true that after 9/13, that is the day before the murder, there is, or the killing, there is no data evidence as far as locations on there?
Again, before you answer that, what do you, tell me in your own words, tell me what you're trying to do that you think I don't want you to do in front of the jury.
Well, I'm right now what I'm trying to do is voir dire the witness ahead of me having to ask either that it occur outside the presence of the jury or ask to voir dire him regarding this matter before it's introduced.
Voir dire for what purpose?
For-
Because that's typically if it's something under the limine, or why do you think I don't want the jury to hear what you're asking is my question.
I mean, like I said.
I mean, we're just not gonna go through so you know what his answers are gonna be.
No, okay.
So it's,
And then
if there's nothing that you think I think is inadmissible, then this is just cross-examination.
Okay, I have one more, Judge. You indicated in the motion in Looney, you granted number 17, which forbid any reference to potential recommended or suggested criminal charges considered or presented to or by law enforcement and or the grand jury other than the charged offense. Specifically, I would like to ask about the pending murder charge associated with Brandon Dodd in this case. Is that something, I mean, when you granted that request, was it specific to this defendant or?
I mean, Brandon Dodd's a co-defendant.
That's correct, Judge. He's charged as.
I don't think there's anything about that that's not going to be inadmissible. I mean, in fact, the copy of the charge that I've already given you has an charge with regard to either being charged as a primary actor or a secondary actor. So no, nothing with regard to Brandon Dodd.
Okay, then I'll
Yeah. Okay.
withhold the rest of my questions.
If I could put something on the record really quick.
Yes, sir.
He's kind of intimated that maybe he didn't get everything in discovery. I would like to put on the record that the state has filed a certificate of discovery that we put on file on October the 4th of this year, memorializing what we either personally delivered to defense counsel or made available on our portal in the way of digital media in this case.
And is the download of Barry's phone on that?
Just, there is, the short answer is there's 52 pages of file names and file directories of data that we have. I am not prepared, as I stand here right now, to say that we either had it or that we turned it over. I represent to the court that we made our best efforts to turn over everything that we did.
Well, I mean, it's not being if it's not been introduced, then there's no objection to it. I mean, what's the?
I mean, the issue is that I don't know if there's exculpatory evidence on that. We didn't get it. In fact, we asked about why we don't have a different extraction, and that question was posed, and then it was determined that we didn't get it because.
So I'll allow you to question that. Obviously, that goes to the investigation, and you can ask the detective about whether he did or didn't do it and where it is, and if he thinks he turned it over, then the state hasn't. I would like to know. I need somebody to start looking through before anybody rests, or before you rest specifically, I guess, Mr. Coleman, if that was turned over and where it is, what it's called, if it's on there and it's just called something else, or I think that's important to know, and then we can go from there. All right?
One last thing, Judge, I just want to make sure we don't have a defense witness sitting in the courtroom who should probably be under the rule. I don't know.
Do you know who that is?
I do not.
Sir, what's your name?
My name's Ryan County.
Okay. Do you anticipate, are you in a relation to anybody here in the?
Lee, yes,
I'm not asking you, okay? What's your relation, sir?
that's my brother.
Okay, do you anticipate using him as a witness for any reason?
Certainly not in guilt innocence.
Okay, perfect. We just want to make sure you're able to be here in the courtroom. If you're a witness, you're not able to be in here, so we just want to double check. Thank you. And then also, I'm going to go off the record.
Okay, I'm having a hard, I can't get into my portal account right now, but
We'll figure it
try.
out. Just that's, so we don't all forget that. It needs to be on file. You can bring the jury in, please. All right, let the record reflect that the jury is seated, state's attorney's present, defendant and defense counsel are present. Mr. Coleman, you may proceed.
Thank you.
And we can, if there's anything that can get sorted out before you come back, we'll do that. If not, we'll continue. When you come back, we'll take 15 minutes and try to get started at 5 minutes till 3. Please keep in mind all the instructions you were previously given, and if everyone else to please remain seated. You're excused for about 15 minutes, and we also can get some fresh coffee out there to y'all probably in just a minute as well. All right, let the record reflect the jury's outside the presence of the courtroom. I know I'm confused, so I'm sure the jury's confused. So let me just see if I've got it right. There was a phone that was known to be the defendant's, and there was a search warrant, and it was dumped, and information
Dumped pursuant to consent, Judge.
dumped pursuant to consent. All right, so we get the dump, we get the information off of it. That information is then used for a search warrant for a Google.
No,
No.
In fact, he
Yes, Judge.
signed it.
Hold on, I'm asking Detective Carmouche,
Yes.
really.
Yes, it was a Google data search, so basically, the email associated with that phone that was dumped previously, which has Mr. Johnson's name on it, you know, that a Geo-Fence be erected in looking for his.
Hold on a second, stop. Stop with all this. I'm gonna give you an opportunity, but all you're doing is distracting me. I have no idea what he just said.
I'm sorry.
I understand that you disagree. Let me get what I think I understand, then I'm gonna give both you and Mr. Coleman an opportunity at the right time.
Yes, sir.
All right. I need to see, if I can, a copy of the warrant.
Ms.
That,
Simmons just pulled it up.
I have it pulled up.
It was
Judge. It's on my
executed
computer.
actually by you, Judge. And so,
I didn't ask that. Hold on. Calm down. Take a breath.
Ms. Simmons just pulled it up.
Can
I
you,
can get you my computer.
why don't, would you email it to me, please? I could probably pull it up on Cloud Gavel also. Let me-
I think that one man was Indiana.
It was, okay,
You don't have a point here.
okay.
I'm almost there, Judge. I had to save it as a PDF to get it to you.
Okay, thank you.
It's been sent, Judge.
How many pages is it?
It's 20, Your Honor.
All right, so for the record, I'm looking at, I have now printed out, search warrant.
with the return, I believe, since that was 20 pages.
Let me see. So I'm on page 3. Which is attachment B. We're just talking about search 1, which is the target, the location data, correct?
Correct, Your Honor.
The probable cause is attached. Okay. Looks like I maybe have two copies of the same thing.
It printed from the same PDF, Your Honor, I don't think it's duplicated. Essentially it is. I think it's saved in Odyssey as a duplicate, so that might be what happened.
Yeah, that's the same thing. Okay. So where in this search warrant is it requesting anything other than that geolocation? I'm confused.
Your Honor, may I?
Yeah.
I think there might be confusion regarding the cell phone dump in terms of the Google location data in which he's speaking of. The cell phone dump was previously admitted by our first witness. Here in the statement of probable cause, you'll see on the, I see it as page 7 on Odyssey, I'm not sure where you're at here. But he even specifies the account to be linked to Google by the Johnson Romeo 285@gmail, which is the direct email he was requesting from Google for them to specify just with that phone. So this is all Google location data reference, it's not the cell phone data.
Okay, it's location data from the
From his
Google,
Google
from,
device.
yeah,
This is, Your Honor, okay, a couple of things in order. So attachment B specifies a location,
correct.
right? And then if you go on to the statement of probable cause, below the paragraph where it indicates that he disclosed information in an interview,
Tell me,
it's linked, he does.
what paragraph? I mean, it's
Okay.
pages long. Tell me where, I know they're not numbered, but is it on the first page, statement of probable cause?
No, Your Honor, so, I'm sorry, it is the,
Or give me some keywords that the paragraph starts with.
so. On the next to last page, it starts the time frame of the Google request,
Okay,
and then it goes on to indicate that there are obfuscated IDs provided in response that do not identify a person. This is the witness's probable cause affidavit, right? These, well, I'll just let you read it. and
yeah,
go-
give me a second. Okay, so this request is for the area around the Ives Street location for any Google
Judge, I
phones.
think Detective Carmouche can speak in more specificity specifically about the obfuscated IDs and how that relates to a potential issue with a Geo-Fence type.
First of all, I don't know what that means. So what is reverse location? I've never heard that word.
Basically, it's the same, it's the opposite of getting your, get the location off the phone. It's in reverse, you're getting it from the actual service itself.
Okay,
So it's going from the other direction.
okay,
And the Geo-Fence in the area it is was told to, in the warrant that was supposed to tell them this ID number, which is, I mean, Google is like if you have an Apple ID and you change phones, it stays on that phone. This is the same thing with Google, so it still will transmit, it still will talk, shake hands with other devices, even if it doesn't have service, because all phones still got dial 911.
Your Honor,
hold on.
And they basically pulls that work.
So in this, I'm looking for the ID that was given.
it wasn't.
May I speak to that, Your Honor?
Yes, ma'am.
I believe, and I think that Detective can.
Hold on a second. I'm gonna go off the record for a
Your Honor, I think Detective can actually clarify this as well. In the second page of the statement of probable cause where he defines or states the name Johnson Romeo 285, I think that's the ID in which he's requesting Google to get the specified information for. It's linked to the specific email, which if you I don't know if you've had time to briefly review it.
Go ahead, point me in the right direction.
If you look through the multiple paragraphs here, it specifies throughout his training experience and whatnot, the Google account, the ID, in this case, the email he's provided, is able to be given to Google for them to formulate the responses for the reverse location in which they receive. It's specified to the email, not the exact ID.
I see, and so I see here right above where there's a Google location history data, right above that, it talks about Johnson Romeo 285 at gmail.com, and that's the device that information was extracted at reason of the judge. Right, so you may make your argument and objection, and then I will make a ruling as to whether or not it will be admissible or not. And this is, we are talking about States 54.
I would, just before the jury's brought back in, Your Honor, I would note that the response to this subpoena that the state is alleging is associated with the defendant contains more than one anonymized, obfuscated ID.
Where's the return? I don't have a copy of what was given back. I guess that's what is on 54.
I don't have the.
So that's what's on, you're saying what is on States 54 is,
Correct.
contains more than just this.
Yes, more than one ID, Judge, and that's because it's not specific to an email address. What Google does, and we've taken seminars on this, what Google does is looks at everybody in one area, and then law enforcement is able to take that data and narrow it down, saying, okay, these particular devices, we want more information with regard to this. If you
That's a
look at-
different, so now that's a different search. I sign those all the time, and that's a very different search warrant than what this one is. And so there are times when I have signed search warrants, for instance, that say, potentially like this, on Ive Street, Verizon, we want everything from this tower from this time to this time. And it gets all of the users that are using their phone or their car or their Google devices. That is different than what this
In
is.
fact,
So
I
I
can proffer to the court that this is what we obtained pursuant to that search warrant. This is what I intend to offer. It is specific, Judge. It is narrow in scope and it is narrow, specific to this particular device.
So what I am going to allow is only information that is specific to the Johnson phone where that email came from. If that is what is on States 54, then that's what I'm going to allow.
That is not all, Your Honor. If you look at line 16, here's their USB.
I don't have that.
laptop.
Judge Simmons did point out that, go ahead, please.
Your Honor, I'm looking at the, I don't think it's labeled as an exhibit at this point, what Mr. Coleman just had proffered to you. There's just one separate specific ID, which,
I see it. It ends in a 913 instead of E42.
no, Your Honor, it actually ends in AF1.
Oh,
That
you
is
don't have the-
actually,
You don't have the full expanded cell on that spreadsheet.
Excel won't allow it to print in landscape with how long the ID is specified to. There's just one that would basically need to be omitted.
Do you
Well-
agree with that?
Well, I don't,
Again, Judge, there's a separate one because two different devices were in that vicinity that night. More of the extraction.
So, but that's what I'm saying is that if there is one, whichever one is associated with Mr. Johnson's, I'm going to allow in. If it's not, I need that redacted, whatever is not from, that should have been returned with that search warrant.
How can you tell the difference?
I'm,
What number is it? What are you looking at?
this is the only one that's,
What's that cell? How
that
that
is
cell?
the reversal, that's the obfuscated ID which you discussed. And what Mark was bringing up.
We got an expanded, or we can expand that cell out, Judge,
Mhm.
in that spreadsheet, and we can see which one that needs to be redacted.
But the question then becomes, how do you know that that's the one
How do you know which one's which?
Detective, I mean, there's an ID number there, right? I mean, that ID number is associated with his account.
Can you show him, hold on. Sit on them. If you need to show him your computer that has the longer one or whatever, y'all need to figure out which ones are which. I'm gonna take a break. Y'all do it off the record. Respectfully, let detective have a moment to look at it and see if there's a way to tell. Attorneys present, defendant and defense counsel are present. Thank you for being here, Ms. Prazzo. And if you have other things to do, okay. Hopefully we'll get there. So everybody's been given an opportunity to kind of look at the information with regard to states number 54. And so, where are we?
Judge, we are redacting the one identifying number on this spreadsheet that is different from all the other identifying numbers. Detective Carmouche has an explanation for why that's the case. It doesn't necessarily mean that it wasn't associated with the Google account for this defendant. It means essentially that
It
perhaps
was just a speculation that it could be a Bluetooth device connected to it, maybe.
A what?
A Bluetooth device connected to the phone itself.
like
Okay.
headphones or
That's a guess.
something. But out of an abundance of caution, we are in the process of redacting.
Okay, Mr. Wilkerson?
Obviously, that, as he just said, is a speculation. I can't, first of all, I can't say agree or not object to them putting incomplete evidence into the record or admitting results of a search warrant that don't include both IDs.
Okay, so do you want both of them in?
Well, if the court's gonna let them in, but
I'm gonna let them in.
I'd like to create a bill of review first, though, before we bring the jury back in.
Okay, so here's where I am on it, just so, and so before you tell them to stop, don't take it out, correct?
Yes,
Okay, we do not want it redacted, correct? If I'm going to let it in, you want it in?
correct.
Okay, so, the reason I believe that, not the reason I believe, the reason I'm going to allow states 54 in, it is the direct result of a warrant that to me appears to be valid warrant, albeit signed by me. I'm not opposed to saying that I did something wrong at times. This, however, is a different type of warrant than normal. The identification on what was asked for was specific. It was in the form that Google requires for that identification. And what they sent back was in some way connected to that identifier. And so for those reasons, I'm going to allow states 54 in. Mr. Wilkerson, you can put whatever you need to on the record.
Okay, and can we also have the court mark this as an exhibit?
What is
The
this?
search warrant and affidavit for the search warrant?
Yeah, it just
Marked as a court's exhibit under seal for appellate review purposes.
as, let's call it, what do you want to call it? Just courts one, if you'll label it, or we'll label it, we'll call it courts one, we'll get it labeled as courts one for record purposes only, which is the search warrant with the attached probable cause, correct?
Yes.
Okay, go ahead.
All right. Detective, before the break, we were discussing our response to a search warrant that was submitted to Google in conjunction with a signature or an authorization by Judge West. In that warrant, attachment A describes what's to be searched, specifically Google. Is that correct?
I don't have it in my hand, but I believe so.
Here, I've got 2 copies, so let's give Detective a copy of what you're asking about. I'm confused now. Give me a second, because I've gotten the two mixed up now. All right, there's search warrant, attachment A. Search warrant. What did I do? Give me a second. Attachment B, and then B goes through this statement of probable cause. Signature. It ends with the two pictures, correct?
Just got one picture.
All right, go ahead.
So attachment A describes Google itself being searched, correct?
Correct.
Attachment B identifies the records pertaining to the search, correct?
Yes.
In attachment B, those records are pertaining to identifying information according to the production protocol described below for Google accounts that report a GPS, cellular, Wi-Fi, or Bluetooth source location history generated from devices that report a location within a geographic region bounded by the following coordinates, correct?
Correct.
And then search one is identifying a time frame to be searched, and then a target location, and that target location is the residence on Ives where Ronald was killed, correct?
And within a commuter radius.
Okay, so if we then go on past B, which reference these production protocols as far as what the response to the search warrant would be, the production protocols indicate that for each location point recorded within the search parameters, that specific location, correct? Google shall produce anonymized information specifying the corresponding unique location obfuscated device IDs of all location data wherever from derived, including triangulation, trilateralization, Bluetooth beacons, precision measurement information, such as timing, advance, or per call measurement data, Wi-Fi location, including the GPS coordinates, estimated radius, and the dates and times of all location recordings, data source and device type during the date and time associated with the specific IDs, and then in parentheses, it identifies the anonymized list, correct?
Correct.
Okay, and when it says that Google will produce anonymized information specifying the reverse location, that is, that house where Ronald was killed, you're alleging that despite that production protocol indicating that what is returned is specific to this defendant, that is actually not an anonymized, obfuscated ID, correct?
One more time.
Okay, so the production protocol referenced in the search warrant specify that Google will provide anonymized information, right? Specifying the corresponding reverse location, obfuscated, obfuscated IDs or devices of all location data, right? And then goes on, correct?
So let me stop you for a second, because are y'all reading this? Have y'all read it in detail?
I have not.
Because here's what it appears to
I think
be.
she's more familiar with it than I am.
So in the probable cause affidavit that's attached to the warrant, it states where they got the information, and that it was an email attached to Mr. Johnson. The search warrant does not, the warrant part itself, including attachment A and attachment B, does not specifically tell Google that they're looking for information related to that email or that identifier. It is specifically, if I'm reading this correctly now that I'm taking my time and calm down, that it's asking for anything, any data within that 50-meter radius during that time period. And what was returned then is what you've got. So in order for that to be relevant and admissible, in my opinion, there needs to be a way for Detective Carmouche or someone to identify those identifiers, relate them back to the Johnson email, if that makes sense.
Judge, not only, well, my understanding of the rules of evidence is that the standard is we have to simply establish it is what we purport it to be. And I think if you look at it in its totality, also, and what I mean by that is the fact that this data, based on the chart that we put together based on the data, if you overlay it on top of the flop camera, on top of the other data points that we have in this case, it tracks this defendant.
So I guess what I'm not going to allow is for, it does not appear that based on, if you take this information away from all of the other information, the question I have is there a way to identify it as that phone? Now, I'm not saying I'm not going to allow it in as some information that was provided based on a valid search warrant for what it purports to be, which is everything that happened in that area within a certain amount of time. And then you lay it over and say, must have been him, use your reason and common sense, you can do all the things that the charge says. But I don't believe that anyone has told me, and if I'm wrong, detective can tell me at this point, that he can say these results are specifically taken by themselves, belong to the Google phone or the Google account or whatever it is that belongs to Mr. Johnson. Does that make it more clear?
Judge, I think Ms. Simmons has something to add to that.
Yes, ma'am.
Looking at attachment B, it does specify the records pertaining to identifying information. It asks you to, I guess, look to the production protocol and look for the initial search parameters, which on the next page where it does specify the production protocol.
Right.
Looking at 1 and 2, it says Google shall query location history data based on the initial search parameters. And then from there, it does go into 2, it specifies for each location, and it asks them to look to the specific reverse location of the obfuscated IDs as well as the device IDs. And then going into the statement of probable cause, he does specify the direct ID with Romeo Johnson.
But this is not a search warrant of, so if you take the search warrant itself, what it's telling them to do, the statement of probable cause is for me, right? That's not for Google to read and decipher what they're supposed to figure out that they're looking for. I look at that, or any judge or magistrate looks at that and says, yes, I think you have probable cause to do this being ask for the search warrant and grant the search warrant to do what it is. So there's no, if it specifically said in attachment B or under those protocols to, and I've seen them where we've done this, C probable cause stated blah, blah, blah. This is in fact it looks different, but this is the typical search warrant that we sign for location data for any people that show up at that, or any devices that show up in a certain area at a certain prescribed time. So all I'm saying is that I still believe I'm going to allow it in. It was based on what I think, under the Four Corners rule, I think the probable cause is valid. I think it gets you to get where we are. And then at the right time, You can triangulate and put whatever on top of you want, and the jury can use it for what weight they want to give it. But I'm not going to allow it to be said that this is downloaded or this information is specific to him at this point. Make sense?
Yes, sir. So, one other thing, the only thing I would ask is whether or not Detective Carmouche has anything else to add to this, as far as linking this
No,
data
let's start
to
into
that file.
obligatory and that kind of.
Yeah. Once we started talking legal words.
Start fading into the bushes.
No, I mean, I guess, so I just want to make sure,
I've got it.
do you see what, I mean, it's the location for whatever's there is what we asked for, what you asked for and what I granted, and the search warrant. And the reason I got there was because he used the identifier in the probable cause, which gave me probable cause to say, yes, that's where he got this location and all of the information that went into it, but
But there's no way detective to link that identifying number that's in that data, in that spreadsheet, back to this phone or this defendant's Google account, as you sit there?
Imagine, imagine they would have it. It would have to be
Well, I mean,
requested, is what I'm saying.
then we can demonstrate to the judge right now as you're sitting there.
okay, all right. So then, again, do you still, based on that ruling, that I'm going to allow it in, but not allow the, it to be said that it is linked specifically at this time to this defendant, but just linked to the area and the time around the Ives house? Do you have an objection?
Yes, Your Honor.
Okay,
I object both to relevance, since it's not established, nor does it help the jury determine that this defendant committed the murder. And so I would ask to continue with my bill of reviewing the search warrant that was provided to Google.
well, it's in evidence. I've allowed the whole search warrant and the statement of probable cause into evidence, and so I don't know that we need to read it all in for the bill of review, since I've allowed it in, so I don't, what else do you, go ahead.
I mean, I would also object that it is substantially more prejudicial than it is probative. Once you say that these are related to this defendant,
I'm not allowing them to say that they're related to this defendant.
but if they're not related to this defendant, then how are they related to guilt, innocence?
They're related to the area where the decedent was found, so they're directly related to the case. So if anything, if they can't relate them to the defendant, then potentially it would be beneficial to you that shows maybe somebody else was there. I don't know, but it's not, it's related to obviously who or something was around. Whether or not they can eventually get to who that was, I don't know, but that's overruled on both of those objections. And will be, again, included as court's number 1 for record purposes.
I understand. Can I still ask him questions before the jury comes?
Briefly,
Okay. So, Detective, is it your allegation that there is some identifier associated with this defendant's phone that links this defendant to this anonymized production?
I think we've already gotten there that he said there's not.
I'd say no, not until, I guess.
Do you understand that in terms of this warrant, that the production protocol advises law enforcement reviewing that anonymized list and excluding people who may be caught up in it that aren't related to the case?
Yes, sir.
Did you do that?
That's I saw that one thing on it, the one item.
And so, in response to this subpoena, 2 IDs were produced, right?
Possibly.
All right. Well, you've had an opportunity to look at the subpoena response, correct? Would you agree that more than one ID exists in that response.
Hold it.
Is that,
He said, I'll agree.
that's all.
Thank you. Anything else before we bring the jury in?
No,
I think obviously for, just need to take a look at these obviously in the future on what specifically is being requested and what's being given so that we don't run into this in the future. You can bring the jury in. And again, I am going to overrule both objections with regard to states 54 and allow it in for the limited purpose of what it purports to be at this time, which is some data from the area surrounding the Ives residence where Mr. Barnes was found deceased. You know what, that one's good. I think that's. Yeah, I have the other copy here. All right, let the record reflect the jury is seated, state's attorneys present, defendant and defense counsel are present. Mr. Coleman, you may proceed.
State offers, I don't know, the state's 54 was admitted, Judge.
It is over the objections that we've discussed during the break.
Commissioner opposed.
Yes, sir.
Judge, I think during our, I think we had an alternative version on 54 based on what the question marks.
Okay.
I think we may need to modify this.
We just need the original. Okay.
It's on the original USB. Now it looks like the file's corrupt. There's may need to make a copy from the original.
Okay. Y'all have the original?
I hope so. So that's corrupt. Do you use blank, save it? So you Simmons uncorrupted.
Thank you, Ms. Simmons. That's what these youngins are good for. Uncorrupting us old ones. All right, let the record reflect the jury's outside the presence of the courtroom. Anything that either of you need to take up before we break for the evening?
No, Judge.
Yes, Your Honor. I really need the Justin Berry extractions so I can make a determination as to whether there is anything potentially exculpatory on there. We know there's potentially incriminating evidence. I've never actually seen it. I've only read it in a report. I don't have the Berry extractions, and I don't know if there's anything potentially exculpatory there. So even though it may not be admissible at this point, I still need an opportunity to review it before, preferably before
Yeah,
the
tomorrow morning.
detectives. Yeah.
Can you get that this evening and get it to
I can
me?
meet you at the station if you want to, I can bring them right down to you.
That would be great. Okay, if y'all will get that taken care of, thank you, Detective. Also, I know you'll be busy doing other things, but I would like you both to start taking a bit of a close look at that charge. I feel like we'll get there at some point tomorrow, and so I want to be ready for anything potentially that you see. I can be working on it up here. If you can kind of give me some direction in the morning if there's something major that either of you want me to take a look at. Okay?
Okay.
Anything else?
One more thing. I think I'm gonna need to call Detective Gillen. I don't have him subpoenaed. He's on the state's witness list. Mr. Coleman has represented that he did not issue subpoenas for the witnesses. And so I don't have a subpoena of the state to rely on. Would the court,
I would think that Detective Gillen would be amenable to making himself available. I don't think, typically, they don't require subpoenas to come testify for the state. If not, then we need to get a subpoena ready and have him served tomorrow first thing. But Mr. Coleman, I think just for the sake of judicial and
I'll reach out.
economy, if you'll please reach out to him and let him know.
I'll reach out to him.
If you will, just see if he could please be available, have himself here and available tomorrow morning, that would be great. Probably not at 9, maybe, but by 10 o'clock, I would think that would be a reasonable time to have him here, so he's not waiting around too long. Thank you very much. Anything else?
that's all, Judge.
That's good.
Okay, we'll be in recess till tomorrow morning. Y'all know how to get in touch with me if you need anything.
This courtroom exchange centers on a high-stakes evidentiary dispute in a murder trial. The prosecution introduced Google Geo-Fence data obtained through a search warrant signed by Judge Raquel West. That warrant requested location data for devices within a defined radius around the victim's residence during a specific time frame. The defense immediately challenged the admissibility of the evidence. Their argument focused on two primary concerns: whether the data returned by Google was properly linked to the defendant's specific account, and whether all extracted digital evidence, particularly from a third party's phone, had been disclosed. The defense emphasized the possibility of exculpatory material existing in undisclosed extractions, raising constitutional concerns under Brady disclosure obligations. Judge West carefully dissected the warrant language in open court. She distinguished between the statement of probable cause, which justified issuing the warrant, and the actual scope of the warrant itself. Her key observation was critical. The warrant authorized a Geo-Fence search for devices in the area, not specifically the defendant's email or account. Therefore, while the search itself appeared valid under the Four Corners rule, directly tying anonymized device IDs to the defendant required additional evidentiary linkage. Rather than exclude the evidence outright, Judge West crafted a nuanced ruling. She allowed the Geo-Fence data into evidence, but limited its purpose. The prosecution would not be permitted to claim that the data definitively belonged to the defendant unless further proof established that connection. This preserved the integrity of the trial while allowing the jury to evaluate the weight of the location data in context. The stakes are enormous. Geo-Fence warrants are controversial investigative tools. Their admissibility and constitutional boundaries are frequently litigated. If improperly handled, such evidence can be excluded entirely, potentially weakening the prosecution's case. Conversely, if accepted without careful scrutiny, it risks unfair prejudice. Judge West's approach reflects judicial caution, ensuring the warrant was valid, acknowledging evidentiary limits, and safeguarding the defendant's right to a fair trial. Her ruling does not determine guilt, but it shapes how the jury will interpret digital location evidence moving forward.